5 seconds to go. Start. Further, on 7th May 2008, the Superintendent of Police Firozabad also sent a letter to the DIG Gwalior requesting for the sanction for prosecution under Section 197 CRPC so that the respondents could be charge sheeted. In the meantime, the respondent number 1 preferred criminal miscellaneous writ petition number 10181 of 2008 before the High Court of Allahabad, and while order dated 23rd July 2008, the arrest of respondent number 1 was stayed. On 30th July 2008, the Superintendent of Police Firozabad addressed one another letter to the DIG Gwalior in the form of a reminder to accord sanction under Section 197 CRPC for prosecuting the respondents herein. However, on 2nd August 2008, the DIG Gwalior replied to the Superintendent of Police Firozabad informing him that sanction for prosecution cannot be granted till the disposal of the trial in connection with case crime number 967 of 2007 registered at the Murad Police Station Gwalior for the offence under Section 34 of the Excise Act. On 28 August 2008, the appellant filed a miscellaneous criminal case number 5971 of 2008 under Section 482 CRPC before the High Court of Madhya Pradesh at Gwalior for quashing the criminal proceedings concerning case number 15003 of 2007 arising out of case crime number 967 of 2007 registered for the offence under Section 34 of the Excise Act pending before the court of CJM Gwalior. In the alternative, it was prayed that the proceeding be stayed till a decision is arrived at in the case pending against Ashok Dikshit before the CJM Firozabad concerning case crime number 617 of 2007. The High Court, vide its order dated 25th August 2009, stayed the proceedings in case number 15003 of 2007 by observing as follows. In the light of the above legal position, the appellant, who is a complainant in the criminal case in connection with crime number 617 of 2007, registered against respondent number 2 at Firozabad, has locus standi to file this petition under Section 482 of CRPC. Now, legal aspect and circumstances of the case is to be considered. Suppose, for the sake of argument, if respondent number 2 admits his guilt in the case of Excise Act pending in the court of CJM Gwalior, what will be its effect? He will have a good ground of alibi that at the time of alleged murder of appellant's brother, he was not present at Firozabad but was present at Gwalior, which is 160 kilometers away from Firozabad. So it will cause a great prejudice in that case, and on the other hand, in the interest of justice, if proceedings pending in the court of CJM Gwalior are stayed, it will not cause any prejudice to respondent number 2. Moreover, it will avoid conflicting judgments of two courts. Therefore, it is a good case for invoking inherent powers of the court. Considering the facts and circumstances of the case, petition is allowed and further proceedings pending in the court of CJM Gwalior in connection with Excise Act pending in the CJM Gwalior concerning case number 15003 of 2007 are hereby stayed till disposal of the criminal case pending at Firozabad concerning crime number 617 of 2007. After a period of almost 1 year, On 25th October 2008, the IO at Dakshin Firozabad recorded the statements of two persons, that is, Ramesh Yadav and Bade Lal, under Section 161 CRPC. Both stated that they had witnessed the respondent number 1 being directly involved in the creation of a false case under Section 34 of the Excise Act in order to provide the accused Ashok Dikshit the benefit of an alibi. Soon thereafter, on 3rd November 2008, a supplementary charge sheet number 3A of 2008 in case crime number 617 of 2007 was filed against the respondent number 1 for the offence punishable under sections 147, 148, 149, 307, 302, 201 and 120B IPC respectively for being involved in hatching a conspiracy of murder that occurred in Firozabad. It was the case of the IO at Firozabad that the charge sheet was filed, since he had found out that the respondent number 1 was not posted at the Murad police station Gwalior at the time of the arrest of Ashok Dikshit for the offence under Section 34 of the Excise Act, and therefore the provision of sanction under Section 197 CRPC would not be attracted against the respondent number 1. It is pertinent to observe here that it is the case of the respondent number 1 herein that the charge sheet number 3A of 2008 was backdated to 3rd November 2008, when in fact it was actually filed on 24th November 2008 before the magistrate. The mother of respondent number 1, while alleging that the appellant was trying to falsely implicate the respondent number 1 in the case of murder, moved an application before the DIG Firozabad requesting that the investigation be transferred from the Dakshin police station to some other police station. The DIG Firozabad wide order dated 11th November 2008 directed the Senior Superintendent of Police Firozabad, for short SSP, to look into the matter. Thereafter, the SSP called for a status report on the case from the circle officer, wide letter dated 14th November 2008. The status report submitted by the circle officer revealed that while the respondent number 1 had obtained a stay on his arrest from the High Court, the arrest of the other accused remained pending and the investigation was still going on. Upon consideration of the same, the SSP Firozabad wide order dated 20th November 2008 transferred the investigation from the Dakshin police station to the Uttar police station at Firozabad with immediate effect. The CJM Firozabad took cognizance of the charge sheet number 3A of 2008, wide order dated 24th November 2008. Immediately on 28th January 2009, the respondent number 1 preferred criminal miscellaneous application number 4080 of 2009 under section 482 CRPC before the High Court of Allahabad, seeking to quash the proceedings in case number 67 of 2008, State vs. Niranjan Kumar Upadhyay, arising out of the above charge sheet in case crime number 617 of 2007, pending before the CJM Firozabad. Later, on 25th February 2009, the charge sheet bearing number 30 of 2009 was filed in the case of the respondent numbers 3, 4 and 5 respectively for the offence under sections 147, 148, 149, 307, 302, 201 and 120B IPC respectively for being involved in the conspiracy to commit murder of the appellant's brother at Firozabad. The CJM Firozabad took cognizance of the same. Wide order dated 10th August 2009. Stop.